Following video is for informational purposes only. It is not legal advice. When an alien enters the country illegally, there are rare circumstances in which the law will forgive the status. Until now, the procedure requires a qualifying alien to leave the United States and re-enter properly. However, since their unlawful presence creates a ban from re-entry, a waiver is required. The waiver is also called the Extreme Hardship Waiver and is very difficult to achieve. Because of this requirement to leave the United States and to risk denied entry, many families choose not to pursue this application and continue to live undocumented in the U.S. On March 30th, 2012, the USCIS proposed a procedural change in these applications. Their plan, not yet in place, is to create a process where qualifying relatives can receive a provisional waiver before leaving the country, if they can demonstrate that being separated from their U.S. citizen spouse or parent would cause that U.S. citizen relative extreme hardship. What this means is that while the alien would still have to leave, they would establish re-entry before leaving their family. The goal of the proposed process is to reduce the time that U.S. citizens are separated from their immediate relatives while those family members go through the consular process overseas to obtain an immigrant visa. If this procedural change is approved by the USCIS, then the current proposal has a list of requirements. What the proposed process would do: an individual may seek provisional unlawful presence waiver if he or she is physically present in the United States, is at least 17 years of age, is the beneficiary of an approved immigrant visa petition I-130, classifying him or her as an immediate relative of a U.S. citizen, is actively pursuing the immigrant visa process and has already paid the Department of State immigrant visa processing fee, is not subject to any other grounds of inadmissibility other than unlawful presence, and can demonstrate that the refusal of admission would result in extreme hardship to a U.S. citizen spouse or parent. An immediate relative would not be eligible for the proposed process if he or she has an application already pending with the USCIS for adjustment of status to lawful permanent resident, is subject to a final order of removal or reinstatement of a prior removal order, may be found inadmissible at the time of the consular interview for reasons other than unlawful presence, or has already been scheduled for an immigrant visa interview at a U.S. embassy or consulate abroad. Allowing immediate relatives of U.S. citizens to receive provisional waivers in the United States before departure for their immigrant visa interview at a U.S. embassy or consulate means that immigrant visa processing times will improve because of greater capacity in the United States and fewer case transfers between the USCIS and the Department of State. Immigrant visas will be issued without unnecessary delay if the individual is otherwise eligible, and the period of separation and hardship many U.S. citizens would face due to prolonged separation from their family members will be minimized. Next steps. This new process will be implemented only after the USCIS publishes a final rule in the Federal Register with an effective date. The USCIS will continue all comments received as part of the proposed rulemaking process before publishing the final rule. The current waiver process remains in place and will continue to remain for those who may not be eligible for a provisional waiver. The provisional waiver application fee is $585 and the biometrics fee of $85. The I-130 fee is $420. If you have any questions about this waiver or would like to consult with a legal professional, please contact the law offices of Gregory P. Sheehan at 1-888-99-GPS-LAW. That's 1-888-994-77 7752, or visit us on the web at www.gregorypsheehan.com. Don't wait. This could be the most important call you ever make. Call us at 1-888-99-GPS-LAW. Again, that's 1-888-994-7752.